Right now, we are listening to live testimony in the courtroom on the Knight case. This is an officer who responded to the scene. This is interesting testimony because he is talking about how the roads were wet and how there were pills found around the victim's body. Joining me now is prominent defense attorney out of L.A., Adam Sostrin. Adam, thank you for joining us.
I love that. I don't know if I'll take prominent, but I'll take it.
It's good to see you. So
good to be here.
What do you think about this? You know, this whole case hinges on a legal technicality of whether or not this is self-defense of others or whether or not there was an imminent threat, an imminent danger that would cause self-defense to be a valid defense. So yesterday we heard eyewitness testimony saying that the bike spun out of control, and then you hear the defense saying, no, the bike fishtailed around and bucked up the front tire, and the family was in danger. What do you make of this testimony we're hearing right now from the officer?
Well, I mean, you know, sort of the point of the defense's case is to show that there was, anytime you're asserting self-defense, you want to show that there's a reasonable degree of force being used against you, and that force is a type of a deadly force, or it's going to cause severe bodily injury, and so you can react the same way. So they want to show that this bike, because the victim wasn't armed, that the bike itself would sort of, you know, be qualified as a type of weapon. And the way that the bike was moving, perhaps that's the reason why the defendant felt that he had to protect others, his family, from the danger of this bike, and he had to use deadly force. So that's sort of why we're hearing about all this testimony right now.
Right, but don't you think that this is circumstantial evidence showing that this deadly force was excessive force in this case, that the roads were wet, that the victim on the bike was intoxicated, he had marijuana in his system, there were a bunch of oxycodone pills spewed out next to his body, and we heard from the medical examiner this morning, let's not forget, where the medical examiner discussed exactly where the bullet lodged in the brain of the victim. I don't know if you heard that testimony earlier, Adam, but the bullet did not lodge the front of the brain, which means the direction of the bike may not have been facing the defendant, but it doesn't mean that it also wasn't facing the defendant's family. What do you make of that as a defense attorney?
Well, correct. I mean, it's a problem, obviously, if he's sort of facing the wrong direction. The point of it being that, well, if he's on his bike and he's faced in the right direction, he's facing towards the defendant and or his family. I mean, the case would be against his family. It shows him being sort of being shot from the back. But of course, if this bike is indeed spinning around, you know, perhaps that's what occurred. And the defense will try to make the argument that no, it still did pose a danger, and you know they didn't know what was going to happen, and you know even because of the wet roads, it could have slid out of control, and it could have caused serious harm to the defendant's family members. I guess that's the only place that they can go.
Right. Okay, so I just got news from the courtroom. We're monitoring it live. We're following it real closely because that's what we do on the Law&Crime Network here. We keep a close watch in these courtrooms. The jurors in the courtroom just broke for lunch, so we're going to spend the next time recapping what we've heard on some of the eyewitness testimony yesterday, some of the medical examiner testimony today, and also, while we have you here, another thing we're going to be covering and keeping a close watch on is the civil trial out of Nevada. This is the David Copperfield case where an audience member was selected to be a participant in one of the famous disappearing acts. During the act of this disappearing, which has been performed by David Copperfield, world-renowned magician, many times, thousands of times, without incident, this audience member tripped and fell and is claiming serious brain injuries. We have a preview of that clip, and let's take a look at it now.
World-famous illusionist David Copperfield might be forced to break the cardinal rule of magic and reveal the secrets of his illusions in open court. Copperfield is being sued in Las Vegas civil court by 57-year-old Gavin Cox, who claims he was injured during a 2013 Copperfield show in Las Vegas. The British tourist who once cooked for British royalty claims he fell and struck his head on the ground after tripping over construction debris as one of Copperfield's assistants whisked him and other audience members through a dark, secret passageway during the disappearing stunt. Cox claims he suffered brain trauma and is forced to wear an oxygen lung at night because he stops breathing when he's asleep. He's seeking punitive damages from Copperfield and MGM for alleged negligence. The illusionist and hotel strongly deny all claims, stating Cox's injuries were pre-existing and or unrelated medical conditions. This is Aaron Keller for the Law and Crime Network.
This is a real interesting case for audience members to watch because we all want to believe in magic, and the illusion behind this magic trick is already revealed in the 13-page complaint that's been filed. We are monitoring this one really closely. Jury selection is in process, and opening statements are set to begin next week. But if we have any updates, we will go there live. Before then, I still have with me Adam Sostrin, defense attorney out of L.A. Adam, you know, these kinds of personal injury liability cases always get me. I practice personal injury law, and I have my suspicions about this case, and I want to get your feeling. Do you feel like this is a case that is a legitimate trip and fall where he suffered serious bodily injury? Or is this a case where they want to get hush money, or they want to bring a claim because it's deep pockets? Because in the complaint, not only is David Copperfield named and all of his entities as does, we also have named MGM. So I know it's going to come down to a battle of the experts and whether or not the medical evidence is pre-existing or not. But what's your take? Is this a legitimate case? Because everybody loves David Copperfield.
Does everybody love David Copperfield?
Everybody loves magic.
Everyone loves magic. He's been around for, I think, like 100 years. I haven't seen him live. And because of this, I obviously don't want to go back to Las Vegas again. Clearly what happened to this person was so unfortunate. I don't know if he's making it up or not, but the fact that if he's having to sleep with an oxygen mask, that's a pretty terrible thing you get from Vegas. Usually it's you're spending too much money, and this is what happened to this poor person. He got picked from out of the audience. I know I never want to get selected, and it's so sad. You know, you do name every single party that could sort of be responsible for the premises, you know, any kind of danger that was on there. So that's why, you know, any person who had ownership or control, that's why all these people are named, and, you know, Doe's 1 through 2000. So I don't expect anything less. But, you know, clearly if I were injured, something like this happened to me, I would probably do the same thing.
Okay, so it'll be interesting to see what the testimony actually reveals in that case and what opening statements are going to reveal as a narrative of what we can expect to see. So far, the defense has been pretty tight-lipped about what we can expect to see in that case. But what we did hear from the package that we just previewed is that the injuries were pre-existing and all unrelated to any trip and fall. So we shall see. We'll keep a close look on that. For now, we will refocus our attention back to the night case because that's what we do have live in the courtroom. The jurors are now on lunch break, but we are prepared to give you some insight into yesterday's opening statements. This is day 2 of the trial, so let's take a look.
Daughter and his son-in-law went on a repo mission to recover a stolen dirt bike. And as things would go, as expected, there was a disagreement over that bike. The defendant was armed, he was ready, and he subsequently took out a .357 revolver, pointed it, pulled the trigger, and fired a bullet into the head of Keith Johnson, causing his death. A dirt bike. A Yamaha YZ80 dirt bike. It was a dirt bike that was owned by Curtis Gill. Curtis Gill was the son-in-law of the defendant. And actually the dirt bike belonged to Curtis's son. And back in 2016, around February of 2016, before this incident occurred, the bike got stolen. They made a report to the Acton Police Department about the bike. There was no word and nothing was heard about the bike for about 13 months. So we fast forward again to March of 2017. And Curtis Gill became aware that that dirt bike, his son's dirt bike, had been put up for sale. And it was put up for sale on an internet website associated with Facebook. And so Curtis Gill decided to go about the process of trying to retrieve the bike, contacting the seller, trying to arrange a meeting, and ultimately hoping to retain that bike. Now, the person who had put that bike on sale was a young man by the name of Justin Badgett. Justin did not own the bike. He had agreed to try to sell it for a friend for an acquaintance of his, Keith Johnson. And the agreement was that Justin, if he was able to procure a buyer and have a successful sale, that he would get some money in return, about $100, like a commission for setting up the sale. The defendant also had on his person concealed a loaded .357 revolver, loaded with 5 rounds. And this was not illegal, for the defendant had just recently obtained his CCW permit, his permit which allowed him to carry a concealed weapon. In fact, he specifically got that permit in January of 2017, about 2 months prior. And so unlike your average citizen, he had the right and the privilege to go through everyday life with a loaded gun concealed on his person. Now, having a CCW permit can give you a sense of empowerment. Having a loaded gun, life and death, right there with you at all times. But with it also goes a huge responsibility not to abuse that power. And in addition to that loaded .357, he had additional ammunition. He had what's known as speed loaders, 2 of those speed loaders. And a speed loader for this type of revolver contains 5 bullets each. And the idea is that if you shoot every bullet in that revolver, you can put all 5 bullets immediately into that revolver. You don't have to waste time putting in one at a time.
You are listening to the opening statements of the prosecution on the William Knight case out of Ohio. With me is our guest, defense attorney out of L.A., Adam Sostrin. Adam, so what do you make of this so far? As listening to this, it seems like excessive force. You know, he went there to go find out if the bike was in fact the stolen bike that he thought would be stolen. He goes there with a loaded gun, 5 rounds loaded, you just heard it there, and he takes matters into his own hands. If he really believed that this was a stolen bike of his son-in-law, Gil Curtis, shouldn't he have brought a cop with him there and not shown up with a loaded gun?
Yes. Unfortunately, a cop wasn't present that day, but that's exactly what any reasonable person would do. If he's sure that that's the gun, what is he doing? He's coming there with a loaded gun. He sounds sort of hot-headed. This is very scary. This is why you try to avoid anything having to do with Craigslist or the classifieds.
Right, but let's make sure we point out so everyone knows he did have a license to carry. It wasn't illegal for him to be carrying the gun. He did have a concealed weapons permit. Though he recently got the permit, it wasn't illegal for him to be armed. However, he did shoot and kill an unarmed man over a dirt bike, which to me seems like excessive force. While the cops were on the phone, they couldn't just wait for the cops to get there. I mean, from my point of view and from a juror's point of view, I'd be thinking, well, gee, we know where he lives. We know where the bike is stored. Let's just get the police involved and let the law take care of itself and not take someone's life.
It's just nuts, but that's what creates good case law.
And good TV.
And crazy things and TV. And that's why we're here, and that's why we're interested in these facts. Who are these people? Who are these people? And here we are.
Right. And just a key thing to pay attention to in this case, while the state has the burden to prove this case of murder beyond any and all reasonable doubt, it is the defense burden to prove self-defense in this case, but not by a much lower standard. The standard is clear and convincing evidence. So let's take a look at the next round of opening statements that while the courtroom is still on their lunch break. Let's take a look.
Curtis Gill, he was in his black Ford truck. He had followed Justin Badgett to the area, and Michelle Gill, she was with her father, the defendant, in the red Chevy truck. Finally, you also hear a 911 call. For when Michelle Gill showed up and was on that front lawn area, she called 911 when she learned that Keith wasn't willing just to get back to bike voluntarily. And she remained on that call throughout the shooting. So you will hear her narrative. You will hear Keith when he revs the engine up in an attempt to get out of there. You will hear the sounds from that dirt. And you will hear Michelle's reaction to what occurs and her description as to what occurs. Right then and there, as it happened. And the defendant, William Knight, took over the phone. He got on the phone and talked to the 911 operator, and you will hear his voice, and you will hear him tell the 911 operator that the neighborhood is converging on the scene. He will admit that he aimed for the chest of Keith Johnson and shot. He will say he did so. His first statement that he did so is because Keith Johnson, or the person, was trying to kill his daughter. As the conversation proceeds, he will say, I did it because he tried to kill my daughter and my son-in-law. And as the conversation proceeds, he will then say, I did it because he tried to kill my daughter, my son-in-law, and he tried to kill me.
This concludes the prosecution's opening statements in the William Knight case. There you can hear the prosecution attorney giving the lay of the land of what happened before the fatal shot happened and lodged into the brain of William Knight. One interesting thing that I'd like to dissect a little bit further with our guest who's with us from LA, defense attorney Adam Sostrin. Adam, in this case, the jurors were taken to the scene before opening statements. So here during opening statements, we're getting pictures of the lay of the land and what happened. But what do you make of the jurors being taken to the actual scene? As you can see there, the scene where the jurors were able to see the exact place where the pills, the oxycodone were found by the victim's body, where the victim's body was found, where the cars were parked. Was that more prejudicial than probative? Why would they do this? What are the jurors thinking? What do you think?
It's not often that the jurors sort of get to go to the crime scene, but sometimes courts allow it in order for, if the argument is made by counsel that it's necessary for the jurors to get an understanding of what the actual scene looked like. And here, it seems to make sense, right? It's such a weird case where there's you have to understand what the road conditions were like, what the street looked like, where it was possible for this motorcycle to spin out. How many feet away was the defendant's vehicle from where the victim was located? So all these things taken together, it's understandable.
Oh, I think we're having a little bit of a technical glitch. I can't hear Adam right now. So I think what Adam is saying is that it was important to bring them to the scene so they could maybe have an idea of proximity on whether or not the shot was cold-blooded murder or self-defense to try to stop an imminent threat. Adam, do we still have you with us?
Yeah.
Okay.
No, I'm still here. And also, I think just before we were talking about self-defense, I just want to say it's nothing the defense doesn't have to prove anything. It doesn't have to prove self-defense, but in any of these cases, the defense sort of needs to raise a doubt about it. And if there's enough evidence about it, the judge will allow a jury instruction that, it'll go through the elements of murder, but then one of the bracketed parts of the instruction that will or won't be included is the defendant's act was justified, and that has to do with whether or not there's a showing of self-defense. And then there's an additional self-defense instruction that shows was the defendant in imminent peril? Did he act reasonably? All these things, and then the jurors can sort of put it together, and they decide, well, was the prosecution able to prove its case beyond a reasonable doubt to the exclusion of any self-defense claims? So I just wanted to raise that. So yes, it's very important in this case to determine really what happened here.
Right.
Was, like as you were saying, was this really imminent? Could it have been imminent based on where party A is located versus where party B is? Especially since the guy on the motorcycle, he didn't have a weapon.
Right. No, that's a good point. But it also is important to point out that in Ohio, that there is a burden on the defense to prove self-defense by clear and convincing evidence. So while the prosecution still must prove their case beyond any and all reasonable doubt, they carry the tougher burden. They have to meet their higher burden of murder, but they could get it could be a lesser. There's no doubt that he actually killed them. So really what's going to turn on this case, which is probably why it was important to go to the crime scene, for the jurors to get a lay of the land, to understand where the cars were parked, where the bike may have, flipped around and fishtailed around and bucked up on the front tire. All of that is important to see whether or not the defense can prove by clear and convincing evidence that it may be self-defense. So speaking of which, the next thing we have for you to listen to, we are live right now monitoring the courtroom, but we also have previously recorded testimony and opening statements from yesterday while the courtroom is on lunch break. So you just finished hearing the prosecution's opening statements, and now we're going to go into the defense opening statements. Let's take a look.
Mr. Gill, after seeing the bike go up and down the street a couple times, pulling out it's like a flashlight on your smartphone. It's dark, I remember. It's almost 9 o'clock at night. And he's using that flashlight to check the serial number because he has one thing that hasn't been mentioned yet. He has the title. He has the title to that bike. He's checking with his flashlight to make sure the serial numbers on the bike match the serial numbers in his title. Mr. Batchett is standing there, and he goes, uh-oh. Mr. Gill says, that's my bike, here's my title. That's when everything changed. That's when Mr. Johnson says, well, give me some money for this. And Mr. Gill says, why? It's my bike. You're trying to extort me for my own bike? And then Mr. Johnson starts the bike up, tries to get away. You're going to hear Mr. Badgett say, ew, that's his bike. Mr. Johnson.
That is defense opening statements in the William Knight case, the dirt bike murder out of Ohio. With us is Adam Sostrin, defense attorney out of LA. So Adam, listening to this, I have two things that come to my mind. Okay. One, they said that we will be hearing from Mr. Knight himself. What do you make of that? You think that's a good idea to put him on the stand and let him explain what happened those moments, or should we be allowing doubt to take over the prosecution's case?
Well, of course, as we were saying before, it sounds like Ohio is a different set of laws than California, where I practice, where you don't have to show self-defense by clear and convincing evidence. Perhaps the defense feels that the only way that they can assert this in this case, and this is what they want to show, is self-defense. The only way they can do it, perhaps, is by his testimony at all, with his testimony alone. At least that's what I'm thinking. That's my take from this. Okay.
And also listening to the opening statement from the defense, one thing comes to mind with me. He shows up with a posse of people, his family.
But he specifically said it wasn't a posse, right?
Well, he shows up armed. He shows up armed with multiple people. He knows that he believes that this is the stolen bike, and that this bike that's been posted for sale by Justin Badgett is of stolen status. They bring the title with them, and they are there to confirm and reclaim ownership of this bike. Why not call the police and get an officer to come with them to confirm the status of the bike and not go through all of this? I mean, what do you think the jury is possibly thinking? He showed up armed.
Why couldn't they wait 5 minutes? But I think what I liked about the defense's opening statement was it doesn't appear that this person's getting ready to commit a murder. It appears that he's just getting ready to collect his property. And the idea being that you never really know who you're going to confront. Your property's been stolen, and he does have a concealed weapons permit, so he is lawfully entitled to have his weapon with him. So he brings it with him, while he's attempting to reclaim this property. And the importance of this testimony is, no, this wasn't, premeditated. If anything, at the worst, this was a type of, voluntary manslaughter, where there was sort of a heat of passion event where he just reacted. That's sort of the importance of the defense's opening statements, and I liked it.
Right. So that could be maybe one of the lessers that could be provided in the jury instruction later if they can't meet the burden of murder. I'd like to take a look at some interesting testimony yesterday while the courtroom is still on lunch break right now. Those were just the opening statements from the prosecution and the defense that we heard. But yesterday we heard from eyewitnesses on the scene. Specifically, we heard from Justin Badgett. Justin posted the bike for sale. He was sort of a middleman. He was told that he could make a commission if he were to post the bike for sale, which he did, and he was there on scene when the altercation began to ensue, when the title of the bike matched the serial number of the bike. Let's take a look at yesterday's interesting eyewitness testimony, because this testimony helps describe the circumstances leading up to those fatal last moment shots.
And tells me go down end of the road, take a right, go down the stop sign, take a left, and it's the second street on the right.
Okay.
And
let me take you back though. When you're on Leonore, you talk with Keith, but did this person Ambrose show up at Leonore?
Yeah.
And did he show up by himself or with other people?
He showed up by himself.
And do you recall what he was driving?
A black F-250 truck.
A black truck?
Yeah.
And as far as at that point, did you recognize that individual?
No.
And did he indicate that at that point you still believe him to be Ambrose, correct?
Yes.
But the decision is made because the bike isn't starting because of the weather to go over to Danby?
Yes.
Mr. Johnson has the bike pointed toward Eastwood, correct?
Correct.
And that way he could go either way on Eastwood, correct?
Correct.
You heard Mr. Ward, a good friend of Mr. Johnson?
Yeah.
Maybe his best friend?
Yes.
You heard Mr. Ward say, just leave the bike.
I don't know if I heard him exactly say that. That's what I assumed he said.
That is the cross-examination of Justin Badgett, the victim's friend, and also the man who posted the bike for sale. To further dissect this, I'd like to bring on our guest, legal analyst, Adam Sostrin. Thank you for staying with us, Adam. So what do you make of this testimony that we're hearing?
Well, it sort of goes against the self-defense claim. It's very helpful to the state's case. He didn't get into the defendant's face. It seemed that he wanted to get away, and then it would just appear that just because of that, well, then how could this have happened? How could there have been a claim that the person was using deadly force against the defendant in this case? It's really hard to show. The only thing they have is perhaps the bike sort of spun out of control, but it doesn't appear that the victim was doing anything aggressive based on this testimony.
Right. Well, based on his testimony, but what we also just heard there at the end of the testimony, that was cross-examination. So it shouldn't bolster the prosecution's case. It should bolster the defense's case. And right before we came out of that, you heard the defense attorney say, you are asked the question about how close of a friend he was to the victim, and I believe that's where he said he was like a brother. So isn't the defense going to show motive to lie or some kind of bias there because they want to hold someone accountable for his friend's death?
Of course. That's the argument that I feel like that's made in every single trial. If there's any kind of relationship whatsoever, clearly there's got to be some bias, and this person isn't to be believed. But the bottom line is this victim who was on a bike did not have a weapon. So it's quite a hurdle for the defense.
Okay, and another relationship that I want to bring the viewers back to was testimony from yesterday. Another eyewitness, Ivan Orlando Stragling. This is the victim's uncle, and he watched the killing and the entire moments leading up to the killing and that fatal shot from the window of the house. So more testimony to listen to from yesterday while the jurors are on their lunch break. But we are watching the courtroom live, and it looks like they are coming back in. But let's take a quick look at yesterday's testimony, and as soon as there's something to bring us back to, I'll bring you back into the courtroom live.
Of injury upon certain psychiatric symptoms.
Right. All told, how many articles do you think you've had published?
Well, I've written book chapters and books. To tell you the truth, I've never counted. I have probably a book, 25 or more book chapters, and a variety of publications.
Okay. Are you a member of any type of organization?
Not right now, no. Okay. I'm not.
We are hearing testimony from a Dr. Jolie Bram. She's a clinical psychologist. Right now, it's a little bit slow in the courtroom. They're just building up her testimony, bolstering her. She's discussing her resume and her credentials and why she is an expert on being a psychologist, and great to talk on this subject. It's still not clear to me on why the state is calling her to testify. Adam, defense attorney out of LA, what do you think?
Well, first of all, I'd like to be bolstered like she's being bolstered right now. I don't know why the state is calling the psychologist. It would be my assumption that after you hear testimony from the defense regarding his, his fear, his trying to protect others, self-defense of others, which is the defense's claim, then, perhaps the state would want to throw in a psychologist as a rebuttal witness or something. But prior to the defendant testifying, this is just part of the state's case. I suppose it's a little unusual to have the psychologist testify at this moment.
Well, it sounds like she interviewed the defendant, and I'm just trying to figure out when. We're paying attention to the courtroom live right now. But before we go back into it, for those of you who are just joining in, a quick recap. This is a case from 2016 when the defendant it's out of Ohio, when the defendant went to go recover a stolen dirt bike of his son-in-law, Gil Curtis. When they arrived on scene and confirmed that it was in fact of stolen status, the serial number of the bike matched the title that they had in hand, and they wanted their bike back. An altercation ensued, some gunshots were fired, and the fatal shot was shot to the victim, Mr. Johnson. This is a case turning on whether or not this is cold-blooded murder or self-defense of others, because Mr. Knight is claiming he needed to shoot the gun to protect his family. Let's take a look at what this clinical psychologist is saying in the courtroom right now, because we are covering this live in the courtroom. Let's take a look.
What did you discover, if anything, about his, let's say, his latter adult years, or maybe the last 15 years?
Well, as I noted, the last 15 years are one in which his role was to be a protector.
Let me stop you there. How old is Mr. Knight?
He's in his early 60s.
Okay. I would suggest he was 63 in March of 2017. Would that sound about right?
Yeah, that's correct.
Okay.
Yes.
He's about 64 now?
Yes. Okay. I didn't know he was 63 or 64, and I was sitting here trying to guess his birthday, but you're right.
Please continue.
Okay. So when he was in his 50s, his wife became very ill. She had throat cancer, multiple surgeries. She was in a coma for 3 months. But what happened to Mr. Knight is he just basically turned all of his energy onto protecting Karen and being there for her. I know she had some nursing through Medicaid. She had a little bit of in-home help. The daughter came by sometimes. But for the most part, the worry and care was on Mr. Knight. And he became more physically debilitated.
You are listening to live testimony of Jolie Brams, clinical psychologist and a prosecution witness. If you've been listening the last few minutes, we're in the William Knight case. Even though it's a prosecution witness, what seems interesting is after they've bolstered her testimony and by having her testify as an expert in her field, she seems to be making a case for the defense on why he might be acting out of fear, how much he loves and wants to protect his only child, his prized child. She seems to be laying the circumstances and the surroundings that would make it reasonable for someone in Mr. Knight's position to act in self-defense under the circumstances of that fatal night when he shot Mr. Johnson. With me, Adam, I wanted to ask you what you thought about that.
Sure, I think it does help the defense. There were competency proceedings earlier, so obviously there was an exchange of mental health paperwork regarding the evaluation of a defendant, which happens in these cases. It's helpful for the defense. Perhaps the prosecutor's thinking, well, they can still get a voluntary manslaughter out of it, which is helpful, again, for the defense. It's the reason they're showing this. The reason the defense would want this is it shows something called imperfect self-defense. Although, in the case of self-defense, you believe that there is an imminent peril, and you respond, and your response is reasonable, and all that to defend yourself. In the case of imperfect self-defense, one of those things isn't true. It's sort of an unreasonable fear that you are in peril, and so the fact that he's a trauma victim. And that he's ultra fearful for members of his family, he's extremely protective. He could have just launched based on that. He was wrong under the circumstances, and he killed somebody.
Right. So do you feel, though, because this is a prosecution witness, that the prosecution is strategically putting her on the stand to so it's not sprung on them later on the defense case? I mean, why else would everything I've heard so far, this is making a case for the defense's defense, which we have to remember in Ohio, the defense does have a burden of clear and convincing evidence. Why is the prosecution witness testifying for the defense? Now, we haven't heard everything yet either. We still have a lot to hear, and this is live testimony. But is that a strategic move?
It might be. Sometimes you want to, if the cat's already going to come out of the bag, if it's already out of the bag, you want to talk about it with the jurors first. I don't know what else she's going to testify to. This is only the beginning of her testimony, but this certainly helps in establishing that unusual requirement in Ohio law, clear and convincing evidence with respect to the defendant's behavior. If it's not self-defense, it's at the very least imperfect self-defense. It helps the defense's case. By having her on, at least, it doesn't mean that the defendant would be fully exonerated or get a full acquittal. You would do that with the self-defense instruction. If the jurors found self-defense to be true, it would be an acquittal. What this does is it means there will still be a conviction, although it will be to a lesser charge. It'll be a type of voluntary manslaughter. And you get this by getting this imperfect self-defense instruction in.
Right. Okay. So speaking of the cat being out of the bag, I want to address, before we go back into the courtroom with live testimony, unless there's something really interesting, we'll break right back in right away. But cats out of bags and rabbits out of hats, I want to bring up other trials that we're following here on the Law and Crime Network. Next week, we can plan to see the David Copperfield trial that's out of Nevada. This is a civil case where there was a slip and fall with an audience member when the audience member was part of a disappearing act. This disappearing act has been performed thousands of times without incident, but in this case, there was a trip and fall, and he is claiming traumatic brain injury and suing David Copperfield and MGM Studios and all the John Does of David Copperfield. We can take a preview of that, but another case we're also following here closely, and if you've been watching us here at the Law and Crime Network the last few weeks, is the Tex McIver case. This is a case out of Atlanta, Georgia. This is a prominent attorney who shot and killed his wife from the back seat of a car while her best friend was driving the car. He claims it was an accident. The prosecution says it was murder, and the motive was financially motivated. So far, if we've been following that case, it seems like the prosecution is having a really hard time meeting its burden to prove murder beyond any and all reasonable doubt. And I have to be honest, when I first heard that case, I thought come on, he's guilty. He shot his wife from the back seat of a passenger car. It seems far-fetched. But as this has unfolded the last few weeks, it does seem like it could be an accident. So next week you can watch that as well live, and hopefully the defense will be putting on their case soon as well. And another thing to know is the Law&Crime Network has an app now, so you can watch these trials live, not only on our network, but on an app. That being said, let's go back to the courtroom live and listen to Julie Bram, the clinical psychologist in the William Knight case, which is the dirt bike case that we've been following closely today. We're going to come back here for just a minute and have some legal analysis while they have a sidebar with the judge. So right now, actually, a very important question was just asked. Probably the key question of why she was called. Based upon your education, your experience, your training, your interviews with the defendant, do you have a professional opinion on what Mr. Knight was thinking that night? What do you think, Adam?
It's just, it's unbelievable. But the fact of the matter is, she did testify that she believed that he's not really a violent person. So what could he be thinking, except perhaps to defend those around him? And if he uses any violence, it's begrudging, and he's not the typical aggressor. So that goes against this being a type of...
She actually said not only not a typical aggressor, but that he had more of a tendency to retreat.
Right. It's incredible. So this is certainly a coup for the defense. It's a surprise that the prosecution is bringing that testimony up, and maybe they assume the defense would afterwards. I don't. It's a little confusing to me because it's so helpful to the defense.
Right. It is helpful for the defense, and that's why they asked the key question right now about her professional opinion, which is the bombshell answer we all want to hear. And then they went into this sidebar, which is why it got quiet on our end and we couldn't hear anything. So if you were to speculate right now about what's going on in that sidebar, which as we can see on the screen, they're all huddling with the judge, what do you think the issue is?
Well, I mean, the expert is sort of not supposed to render a legal conclusion with respect to, what is her answer with respect to whether a crime was committed that night. Certainly not supposed to go that far, but they can render other types of conclusions. Were they saying basically that they should refer to the report, the written report that was already done, and not have such a conclusory statement or answer? Well, cat is out of the bag. Rabbit is out of the hat. It's happened. I don't think it really matters what's happening in sidebar anymore. Right. They are certainly taking some time there discussing it. I didn't hear an objection ahead of time either, but she didn't get to answer the question, which was the question we were all waiting for, because we all want answers. Like, why is this specific witness called to the stand, and what specific testimony does this witness have to offer to lend credibility to the prosecution's case, or to help the defense poke holes in the case? What were you going to say? So far, she's been nothing less than magical for the defense. Right. Well, okay. Well, if we want to see magical, we'll have to watch next week with the Copperfield case. But with this one, I guess we're just going to continue with the sidebar. It looks like nothing else is going on here. So let's talk about this case a little bit more. Okay. What do you think the jurors are thinking? Well, I think the jurors are thinking what everybody's thinking the jurors are thinking when you hear testimony like that, that this isn't a person who came over to commit a murder. He didn't go over to meet with the victim in this case to kill him. It was just his unreasonable fears about things and the trauma that he had in the past. And he probably did think he was defending somebody. Maybe that fear wasn't reasonable, but it goes to self-defense. It goes to voluntary manslaughter by imperfect self-defense. Right. It's so helpful. It's so helpful to the defense's case. Right. Well, and as we know, the juror is going to have to weigh all the evidence and take it all into consideration. Let's go back into the courtroom live because the sidebar just ended. Let's see if she's allowed to answer the question and what she has to say.
You are listening to live testimony of Dr. Jolie Brams. She is actually a defense witness called out of turn and is now being cross-examined by the prosecution. So due to scheduling conflicts, she's now on the stand. And before we have to let our wonderful guest go, Adam, I wanted to ask you just a couple questions, just listening to this and summarizing what she's saying. On cross-examination, it appears to me that he's asking her, how much does she charge per hour, which was $300, that he sat with her for 3 hours, and she interviewed him, and she interviewed family members, and she had to prepare for actual trial, and now she's getting paid for her time here, that her opinion is not really reliable, that it was paid for and is biased. What are you gathering from this, and what do you think the jury is gathering from this?
Right. This is something that happens in every single case. They always want to know how much money somebody's getting paid to do what. It's pretty normal. And just the mere fact that they're getting paid, it means that they're a biased witness. It's kind of annoying. The district attorneys make a lot of hay out of it, but I don't think they should, because everyone's got to make a living. And you're an expert in a field. You get called. You get paid a certain amount of money based on your experience. It shouldn't have anything to do with any kind of a financial motive. Shouldn't make it seem that the witness can't be impartial. Of course, you call a witness for a certain reason. You want them to be helpful to your case. But the mere fact that they're getting paid, it's annoying. And I hate how prosecutors harp on it.
Right. Well, but they're also harping on the fact that she only interviewed him for 6 hours. It was sort of an isolated incident. He asked her probably 3 different ways whether or not her opinion would change if he convinced her that the facts changed. So he's really trying to undermine her testimony.
Of course he is. They have to go to the length of time that was spent with this person. They have to punch holes in it somehow. As I said before, her testimony is pretty magical for the defense's case. The prosecution wants it to be a lot less magical. So these are the things that you would do.
I would say she's a strong witness. What do you think the jury thinks?
I would say I will stop using the word magical. I will also say that she is a very strong witness. And I think the jury feels that way, too. She seems to be credible to me.
All right, Adam. Well, thank you so much for your time and for joining us. I know you got to sign off and get back to your lawyering, which I totally understand. But thank you so much for joining us. And we're going to go back into the courtroom live and pick up this testimony with this witness, which is still on cross-examination.